andito ang liwanag, name of congressman, ilagay yung district at saka yung partido, nakakaintriga. At yun siguro. Nandito po yung Comelec, kanina pa nag-iintay, kung okay lang sa inyo, tuloy na tayo kay Chairman George Garcia at yung iba't iba pa. Na narito, ang pagkaalam ko, si Senator Francis Tolentino ang interesado magtanong, andito ang lahat ng Comelec commissioners natin, puwera lang kay Commissioner Perolino. Pero lahat kumpleto. Maraming salamat.
Madam Chair.
Yes,
Madam Chair.
I think Senator
Go ahead,
Francis
Madam Chair, because I thought you wanted to talk about the Comelec.
We're already beginning with the testimony of Comelec.
Thank you, Madam
Thank you.
Chair. Wala po akong tatanungin sa ibang mga resource persons. Rather than, I'll focus sa Comelec. Yesterday, an en-bank resolution came out. May we know, may this committee be clarified as to the current operative legal framework that we have now?
Madam Chair, Your Honors, magandang hapon po. As far as the Comelec is concerned, as of this time, our resolution 10650, the one that we are using for purposes of the People's Initiative, is suspended. And therefore, as far as we are concerned, our local Comelec election officers will not accept anything from anybody submitting any document concerning any signatures. At the same time, lahat po ng aspeto ng proseso ng People's Initiative are likewise suspended as of this time.
With the sufferance of Senator Tolentino, may I simply recognize our legal luminaries. We are honored by the presence of Justice Adolfo S. Ascuna, who may interject at any point. Our good Justice Tony Carpio, the Dean of La Salle, Jose Manuel Chel Diokno. I think Attorney Romy Macalintal is also here. And I invite you to interject and participate in this discussion at any point. Thank you.
Madam
Yes,
Chair,
Senator
may we
Tolentino.
clarify from the good chairman, what is the meaning of this interpretation of suspend? You suspend the effects, you suspend the implementation, suspend the acceptance of signatures. Ano po yung eksaktong para maintindihan ng mga kababayan natin?
Suspend all in all, suspend the acceptance, suspend the implementation, suspend the execution, suspend anything in relation to the People's Initiative, because that is the law. That is the rule that we are observing. We honestly believe, Your Honors, Madam Chair, that Comelec Resolution 10650 in its present form and content is insufficient.
Thank you, Mr. Chairman. But yesterday, we also heard from Total News reports that you intend to reframe, rehash, correct the existing Resolution 10650. Ano po yung gagawin? Mabaguhin o i-amend? You found loopholes? Ano po yung gagawin doon?
Maraming salamat. Kasama na rin po, Madam Chair, Your Honors, yung enhance. Kasi po, Madam Chair, yung mga pinag-uusapan po kanina pa dito sa committee, katulad po ng mga issue ng may issue ng paggamit ng pondo, halimbawa. Sa Section 16 po ng Comelec Resolution 10650, nakalagay po doon, bawal ang paggamit ng public fund for purposes of signature campaign. Pero yung pong provision na yon ng Comelec Resolution 10650, hanggang doon lang po. Wala pong nakalagay doon sa issue ng, are we going to remove the names? What will happen to the names of these people who perhaps have received something from anybody? Wala po sa rules yun. So, ibig sabihin po, pagdating, kung sakali po magkakaroon ng isang formal petition sa Commission on Elections na hanggang ngayon po ay wala pa, magkakaproblema po kami, Madam Chair, Your Honors, yung mga local Comelec namin will insist just by looking na lang po sa signatures and determining whether they are voters. They may not even accept any objection to each and every signature because it's lacking in our rules. Isa pa lang po yun sa mga instances, Madam Chair, Your Honors, ng magiging problema later on kung sakaling we will allow this entire process to proceed.
And may we know from the good chairman, how long will this curative process last? Ganong katagal yung gagawin to?
We are hoping, Madam Chair, Your Honors, that nobody or not even a single group will be pressuring the Comelec to immediately come up with a guideline. Alam niyo po, Madam Chair, yung pong kaso ng Lambino versus Comelec, 2006 po yun. The ponente of which was Justice Carpio. It took the Comelec 14 years to draft Comelec Resolution 10650. So kung 14 years nga po yun na-draft so sana po wag kaming ipilit na mag-draft kaagad ng guidelines.
Kaya ko po tinatanong to, Mr. Chairman, is that we're not discussing here we're not questioning the constitutional authority of the Commission on Elections to craft its own rules. But kung babalikan natin, Santiago case, operative order is inadequate. Republic Act 6735 is inadequate. Kung babalikan po natin yung Lambino case, Lambino never overruled or modified Santiago case. And yet, the Commission on Elections came out with its own resolution akin to an IRR, which, as far as my interpretation is concerned, which provided some curative measures insofar as the inadequacy of previous Comelec resolutions. Sa tingin niyo po ba, Chairman, mas mainam na gumawa na lang ng batas ang Kongreso to amend Republic Act 6735, which the Supreme Court termed as inadequate, and also in that decision, the Supreme Court stated that Comelec should be permanently enjoined from entertaining or taking cognizance of any petition for initiative on amendments in the Constitution. Baguhin muna namin yung batas bago kayo gumawa ng Comelec resolution, o ituloy nyo po yung paggawa ng Comelec resolution, amyendahan nyo yung Resolution 10650 circa 2020. Ano po yung the respected magistrates can jump in. Ano po yung mas mainam na gawin dito? Baguhin mo namin yung Congress should amend 6735 or Comelec should amend Resolution 10650. Para mas matibay po, para once and for all kung ano yung pagkukulang na nakita sa Santiago case na hindi naman na-tackle doon sa Lambino case, although meron 10 obiter doon. Ano po yung mas mainam sa tingin niyo po, Mr. Chairman?
Madam Chair, since ang Comelec po under the Constitution, under Article 9C, Section 2, is just there to enforce and administer election law, we will highly respect whatever is the wisdom of Congress in this matter. Although we have our own opinion as regards Republic Act 6735 po, when it comes to whether it is sufficient or not. Hindi po kasi kami pwede magsalita hanggang ngayon sapagkat that would be the basis of any future resolution of the Commission in the event that a formal petition will be filed in the Comelec. Kasama po yun sa sufficiency in form and substance, Madam Chair, Your Honors. And so it's premature at this point for the Comelec to jump in and make a statement as regards the sufficiency or insufficiency of Republic Act 6735.
Oh, Mr. Chairman, wala po kayong rekomendasyon sa committee ito na baguhin na lang po na para sigurado na tayo kasi may provisions pa ho ako na encounter yung sa initiative there is such a thing as direct initiative and indirect initiative. So hindi ba mas maganda ang klaruhin na lang ng panibagong batas ito para once and for all the law will set the appropriate standards on how Comelec should act, issue the appropriate resolution. Wala na ho tayong gulo. Kasi akit na naman po ito sa Supreme Court. Sasabihin ng Supreme Court, mawalang galang na si kay Justice Ascuna, professor ko po ito, akit na naman sa Supreme Court. Sasabihin na naman sa Supreme Court, sinabi ko na sa inyo na ganito ito. Hindi na tayo matatapos dito.
Maganda pong suggestion talaga po kung magkakaroon ng pagbabago sa batas para ma-clarify na ang lahat. It should not be the Comelec that should be clarifying anything. Our IRR should not be there to correct whatever mistakes, if there are, doon sa batas. Hindi po yun ang role ng implementing rules and regulation. Ang dapat
What's
po yung
happening right now, Mr. Chairman, is that the Comelec will be correcting its previous IRR. And the previous IRR was made to supplant some loopholes found in RA 6735. So baguhin na lang natin 6735, tapos issue ng, or perhaps the Congress can make a very tight law na hindi na kailangan ng IRR. Kaya ko po sinasabi to, Madam Chair, napakarami na pong pangyayari na yung IRR, iniba yung batas. Meron po akong encounter doon na wala na dito yung mga tiga Department of Health, yung
Senator
Milk
Tol?
Code of the Philippines, binago nila.
Follow up lang ako
Yes, yes.
sa sinabi ninyo. Okay lang. For all our legal luminaries, the justices who are here, perhaps you can help us. Perhaps the reason why Comelec Resolution 10650 is so defective is because the law nga that is trying to implement it, RA 6735, is insufficient to cover the PI as conceived in the constitutional amendment. Could this be the case? Because in the decision of Lambino versus Comelec, I believe the ponente being here, the Supreme Court categorically declined to revisit the Santiago ruling. Assuming for a moment that no motions for reconsideration were filed in Lambino, would you agree, Chairman Garcia, that the Santiago ruling remains valid? Because you have given interviews stating the contrary.
Madam Chair, Your Honors, this is a personal opinion as a former Dean of the College of Law and a former law professor. It will not bind the entire commission because it's being asked of me. With the kind indulgence of everybody, if we are going to read the case of Santiago versus Comelec, indeed, the voting was 8-6 in favor of insufficiency. However, Madam Chair, Your Honors, if you are going to read the motion for reconsideration, there was a sudden turnaround. It was a 6-6 voting, Madam Chair, Your Honors. In that 6-6 voting, Justice Hermosissima reversed himself and sided with the 5 who voted to declare 6735 as sufficient. And Justice Vitug refused to resolve Republic Act 6735 on its insufficiency or sufficiency. One justice inhibited himself, and the other justice said it's premature. That's why the voting after the motion for reconsideration.
But Chairman, the reality is, in its resolution of November 21, 2006, the Supreme Court dismissed all the MRs. Even if there was a sentence in that resolution saying that 10 members reiterated their position as shown by their various opinions, the decision is upheld as sufficient and adequate to amend through a people's initiative. Are you saying that this single sentence reverses the Santiago ruling?
Madam Chair.
Yes, let him answer, please.
Madam
Chairman
Chair,
Garcia,
Your
please.
Honors, a reading of the dissenting opinion of Justice Panganiban, of Justice Reynato Puno would reveal that what was mentioned in the decision as to be having an injunction, a permanent injunction, is the Delphine petition. It is never intended by the court to be a prohibition in future cases for purposes of the determination of the applicability
Yes,
of
I don't
6735.
think that's the question we're asking. It's very clear from the statement that the separate opinions of the 10 justices already mentioned had promulgated their opinions as early as October, before the MRs in November. Upon the resolution of the MR, the 10 justices merely reiterated what they had already said. So if the separate opinions of October 25, Lambino Ponencia, were not enough to overturn Santiago, how can the mere reiteration of these same opinions in November 21 suddenly overturn the entire Santiago doctrine?
Madam
yeah.
Chair.
Yes.
If I may, Madam Chair, just to add to the response of the good chairman to the chair's question, maybe the chair could also ask Justice Carpio to weigh in on this question.
Yes, I
Madam
was going to
Chair.
allow Chairman Garcia, and then after that, of course, the very enlightened and personal knowledge of Justice Carpio. Yes, Chairman Garcia.
Thank you very much, Madam Chair, Your Honors. As far as because we are talking now of the Lambino versus Comelec decision, indeed, there was never, the Supreme Court said that they are not at liberty at that time to depart from the ruling in the case of Santiago versus Comelec. But however, again, it's subject to interpretation in the motion for reconsideration. There was this one paragraph which says that 10 justices of the Supreme Court are of the opinion that Republic Act 6735 is sufficient.
With the permission of the good chairperson. But as,
Still have the floor.
just on this point, Senator Tolentino, But as lawyers too, Chairman Garcia, again, you're expressing your personal opinion and not in any way binding the commission. It is clearly obiter because it was not needed to dispose of the case. The case was already disposed of. That statement had nothing to do with the disposition of the case on the merits. Now, I will not bind you to an answer, but a lawyer can interpret that too, in that manner. That although that statement was made in the minute resolution of Lambino, that is obiter insofar as the main case which the court disposed of already, as Senator Marcos said, all of the cases and petitions were dismissed. It would be fair to interpret it that way as well. Would that be a fair statement?
Coming from a very respected legal luminary such as the Honorable Senator, we will definitely respect such a position. But of course, that will be the subject of a future litigation again in the Supreme Court. That's why, again, perhaps it's the best time that this legal issue be resolved with finality by the Honorable Supreme Court.
Thank you, Madam Chair. With the indulgence of Senator Tolentino.
Thank you very much, Senator Tolentino. Would you like to invite Justice Carpio at this point?
Justice Carpio can join us.
Yes, Madam Chair, Your Honors. If you look at the main decision in Lambino, you have to look at the dispositive portion. The dispositive portion, which is the binding portion, says the petitions are dismissed. And then in the motion for recon, it's the resolution of the court says the MR is denied with finality. So there is no reversal of Santiago because you have to look at the dispositive portion. That is the portion that binds everybody. So the statement in the MR that 10 justices maintained their position is just a statement of what these 10 justices said, which was already ruled in the main decision. So the dispositive portion should prevail. And there is nothing in the dispositive portion that reverses Santiago. Thank you.
Thank you very much for the very simple and truly enlightening clarification, Justice Carpio. I know that you had a previous engagement and you made a real effort to join us, so thank you for your participation. It's been most enlightening and clarifies that, in fact, Lambino does not repeal or change the Santiago ruling. Thank you. Senator Tolentino,
No
please.
further questions, Madam Chair. Perhaps the next step for this Congress to do is amend Republic Act 6735, and then the Commission on Elections to issue appropriate resolutions to implement the amended law. Unless Justice Ascuna would want to say something. Wala na po akong itatanong, Madam Chair. Salamat.
Maraming salamat, Senator Tol, and we'd like to call on Justice Ascuna, who's waited patiently from early this morning. If Senator Cheese will allow the justices to please first take the floor. Thank you, please.
Thank you, Madam Chair. In connection with the Lambino versus Comelec, I was one of the justices who voted in that case. I was one of those one of the 10, whose opinion was that Republic Act 6735 was sufficient to support an initiative to amend the Constitution. But the ruling was that there was no need to examine whether or not the Santiago ruling should be reviewed, because in that Lambino case, it was very clear that the proposal was a revision, and therefore it cannot be done by initiative. So the ruling was petition denied because it's one for revision. In the motion for reconsideration, it is true that there's the last paragraph that says that the 10 justices maintain their position that the law, Republic Act 6735, is sufficient. However, I believe that, although I was one of the 10, I believe that that is not a binding statement. It merely reiterated our obiter dictum, our academic opinion, what is not part of the ruling, because as the main decision said, it is not necessary to go into that. That is what Justice Holmes called economy of jurisprudence. You decide only what has to be decided. You reserve for future cases what needs to be decided so that it will not bind future Supreme Court. That is economy of jurisprudence. So I respect that. Furthermore, Madam Chair, if we had reversed our position and reverse Santiago, the dispositive portion would have partly granted the petition, not denied completely. It would have said, wherefore the petition is partly granted to the extent that Santiago versus Comelec is reversed. But the petition is denied because it is for revision. But we didn't do that. We denied the petition completely. So that means we did not go into the review of Santiago versus Comelec. The same with the motion for reconsideration. It was, the dispositive portion said, all the motions for reconsiderations are hereby denied. Otherwise, it would have said, partly granted by reversing Santiago versus Comelec. We did not. So as Justice Carpio said, it's the dispositive portion that counts. And the dispositive portion in the Lambino case very clearly did not reverse or even touch upon Santiago versus Comelec. And therefore, I believe it still stands. Moreover, Madam Chair, the deficiencies pointed out by Chief Justice Davide in Republic Act 6735 in the Santiago versus Comelec case, that it is insufficient, inadequate, and incomplete. Why? Because it does not state what the petition should contain, whereas it states what the petition to make an ordinary law should contain. It does not state what a petition to amend the Constitution should state. Moreover, it says that the change shall be effective upon publication in the official gazette. Whereas in the case of an amendment of the Constitution, it is effective upon the plebiscite, approval in the plebiscite. So it is incomplete. There's no provision on the effectivity of the change. There's no provision on the content of the petition. Now, can the Comelec supply that deficiency? I respectfully submit, Madam Chair, that the Comelec cannot supply that deficiency. There has to be a law. Why? Because the Constitution says that Congress shall pass a law to implement this initiative. That's in Article 17. Congress is the one mandated to pass the law. And there is a principle in constitutional law called potestas delegata delegare non potes. Where the Constitution has put the power, it shall remain there. It cannot be transferred elsewhere. And so therefore, the Comelec cannot do it. Moreover, under the provision of the Constitution on the Comelec, the powers given to the Comelec is to enforce and administer the law, not to complete it, not to perfect it, not to supply deficiencies, enforce and administer. So if it is incomplete, imperfect, inadequate, you cannot enforce it. You cannot administer it. There is a need for Congress to pass a law that is adequate, complete, and sufficient. In fact, there is a pending resolution of the pending bill in the Senate for that. Senator Coco Pimentel has a pending bill to correct the deficiencies of Republic Act 6735. I think that should be the case.
Thank you very much, Justice Ascuna. And assuming, without conceding that RA 6735, I think perhaps you're the right person to ask, assuming that this is in fact sufficient for argument, to implement the constitutional provision on people's initiative, you made mention and distinguished between a mere amendment and a revision. I would like to ask you your opinion based on the signature sheets that have been passed around. What is being proposed in Section 1, Paragraph 1 of Article 7 of the Constitution is a change in voting jointly at the call of the Senate President or the Speaker of the House. Do we then consider that this is an amendment, or a revision of the structure of government and bicameralism?
Madam Chair, in my personal opinion, the proposed initiative now is not a mere amendment, but a revision, because it affects Article 6 of the Constitution, not just Article 17, because it changes the nature of the legislative body from a bicameral one to a unicameral, in effect, because by voting jointly, the Senate and the House will become, in effect, a unicameral body. There is another provision in the existing Constitution which provides where Congress may vote jointly. That is during imposition of martial law. But that is in the existing provision. That was not introduced by initiative. If you want to change the voting, it has to be done by Constituent Assembly, not by initiative. And Constituent Assembly, you need the Senate to participate. That's why it cannot be done. So that's the problem. The problem I was testifying before the House of Representatives, their problem, Madam Chair, is paano naman kami? Approve na namin ito, ngunit ayaw ng Senado. I told them, well, you can't do anything because it has to be both of you. Now, if this is approved, assuming it's all right and it's approved by our people, and so now Article 17 will read that one of the ways of proposing amendments or even revisions to the Constitution is by a vote of Congress, by 3/4 of all its members voting jointly. Okay. Does that mean that the Senate is out of the picture? I don't think so, because it says Congress, and Congress means Senate and House, and therefore you need at least 12 plus 1 senators to vote with the lower house for it to be a valid act of Congress. Because if there is no majority vote of the Senate in that, let's say you have 315 representatives and 24 senators, you have 339 in all, and 3/4 of that is 254. Of the 254, 13 has to be senators. Otherwise, it's not an act of Congress, because it's not an act of the Senate. And Congress is Senate and House. So even if you vote jointly, it has to be jointly with Senate and the House voting together. And if the Senate is not present, let's say there's no quorum on the part of the Senate, then even if the 315 congressmen vote in favor, it does not propose an amendment, because it's not Congress. It has to be both Senate and the House acting together, even if outvoted kayo. But there has to be a participation of the Senate, and that means at least a majority vote of the Senate. You can even change your rules, Madam President, Madam Chair. Your rules state that your quorum is majority plus 1, or 1/2 plus 1. You should change that to say that if the matter being considered is a proposal to amend the Constitution, the quorum is 3/4 of the Senate. And if it is a matter of calling a constitutional convention, it is 2/3 of the Senate. And that's your quorum. So if none of you will attend the so-called call by the House Speaker, imagine the Speaker can call both the Senate and the House under the amendment. Supposing none of you will show up, or less than the quorum, they cannot proceed because there is no quorum. Now, if they cannot proceed, they'll order the arrest. The Speaker will order the arrest of a senator? Is that possible? So that is the problem, Madam President. Thank you.
Thank you so much, Justice Ascuna. And certainly in Lambino versus Comelec, the court stated that altering the principle of separation of powers or the system of checks and balances amounts to a revision, an entire revision that is not a mere amendment. I'd like to hear from the Comelec. Do you agree with this? Do the other legal experts like Dean Jokno and the rest agree with this?
Madam
Yes,
Chair,
Comelec, please.
Your Honors, with all due respect, that's premature at this point on the part of the Commission. There being no petition yet before the Comelec, and we do not want to preempt the action of the Commission. It's just sufficient that we are listening intently on the the statement and the opinion of Mr. Justice Ascuna and Justice Carpio.
I completely understand and respect the position taken by the good chair, given that this might be ripe for their own adjudication at the proper time, and it would be premature to ask for his opinion on the matter. Suffice it to say that the lecture given by our distinguished former justices and Chief Justice of the Supreme Court would more than suffice, especially given the fact that I will qualify them as to their expertise. Not only were they part of the Lambino case, but not only were they part of the Supreme Court that decided at that time, the ponente is Chief Justice Carpio himself. Kumbaga sa pagtitingnan niyo yung intent ng Kongreso sa mga batas na ginagawa namin, parang ito na rin yung intent ng Korte Suprema, kumbaga, nung yung desisyon ay binaba at ginawad patungkol sa petisyon ng Lambino case. May I just ask one question to the distinguished Comelec Chairman for his consideration and for the Comelec's consideration, Madam Chair?
Yes, please proceed,
Digressing a
but in the meantime, of course, we also recognize that Justice Ascuna, in addition to his participation in the Supreme Court, was one of the framers of both the 1973 Constitution as well as the 1987 Constitution, and we are fortunate also to have the presence of Justice Carpio, the actual ponente of the Lambino case. Yes, please proceed, Senator Chis.
Now, may I confirm, Chairman Garcia, Comelec is an independent constitutional body, right?
Mr. Chair, Madam Chair, Your Honor, yes, that's true.
So as such, you have fiscal autonomy. Would that be correct?
That is correct, Madam Chair.
As such, you're given by the power under the Constitution to realign funds within the Comelec's budget. Would that be correct?
That is correct, Madam Chair.
Now, given that your original budget proposal to the DBM, when you were submitted to asked to submit a budget proposal during the budget call was 43.716 billion, and the DBM only gave you 27.103 billion. There is a differential that you would have wanted to utilize for purposes of performing your functions as a constitutional body. Would that be correct?
That is correct, Madam Chair, 17.4 billion.
Now, specifically, you proposed 2.57 billion for the conduct of supervision of elections, referenda, recall votes, and plebiscites. Would that be correct? You proposed that.
2.5 million, yes, Madam Chair.
And then all of a sudden, the BICAM recommended 14 billion, which actually increased it by 12 billion. Would that be correct?
12 billion for the conduct of recall initiative, referendum, and other election preparation, and 1 billion for the preparatory national and local elections.
Yes. And yet you had other submissions for capital outlay and for PS that were not granted.
That's right, Madam Chair.
So, as you stated earlier, now that for the information of everyone, given that it was stated by Senate President Zubiri, now that the President has taken a position against People's Initiative, you are reviewing the rules of Comelec with respect to the supposed law of 6735, would there be a possibility that the Comelec will revisit the 14 billion item in your budget, realign it for the purpose of spending it on what you really need, on capital outlay and PS, that is the creation of positions, which is well within your power to do so. Would that be correct?
Madam Chair, Your Honors, and this is for the record, even before the NBank had voted yesterday to suspend any and all proceedings, including the effectivity of our Comelec Resolution 10650, we already had in our mind the items by which this 13 billion pesos to be spent, and definitely all of these items which this representation is willing to submit to this committee does not pertain to any people's initiative or any plebiscite in relation thereto.
Can you submit, Mr. Chair, once it is done, the realignment of Comelec insofar as these allocations are concerned? Again, given that Comelec as an independent constitutional body can realign from within your agency, given the direction given by the President as well, and how things are running.
Yes, Madam Chair, Your Honors, we will do that. In fact, we will return to the items which were reduced as far as the amount is concerned, ibabalik po namin lahat, yung lahat ng nawala sa amin.
Kindly inform us when this is done, Mr. Chairman.
Definitely, Madam Chair, Your Honors.
Now,
Thank you very much.
on the resolution to suspend further consideration of this people's initiative, the ground given was that you would review your rules. Would that be correct?
That is correct, Madam Chair, Your Honors.
For the information of the good Comelec Chair, there are several petitioners, including the Senate, who are planning to seek a clarificatory ruling, as may be necessary from the Supreme Court, because as stated by Justice Azcuna, how can you come up with rules for a law that is inadequate and insufficient? Although I acknowledge the fact that these rules were issued prior to your term as Chairman of the Commission on Elections.
That's right, Mr. Chair, Madam Chair, Your Honors, but the suspension of our rules does not preclude anybody going to the higher court to question the same rule that we suspended.
Again, just informing the good chairman that there are such plans to go up before the Supreme Court to precisely question that, and perhaps this would be considered as a condition precedent, given a pendency of a case should that time arise this week or next week, for the Comelec to be more prudent in issuing new ones until, if at all, those cases are resolved when the time should come.
Definitely, Madam Chair, Your Honors, we will seriously consider the suggestion of the good Senator.
Thank you, Mr. Chairman. Thank you, Madam Chairman.
Madam Chair.
Madam Chair,
Thank you very much. Senator Tolentino, please.
There's a manifestation.
And thereafter, Senator Risa, is that correct? Thank you.
There's a manifestation of gratitude. I'd like to thank Justices Carpio and Azcuna for clarifying all of this as a constitutional law junkie. I think, Madam Chair, I think we have to really assert the Senate's right to implement Article 6, Section 16 of the Constitution, which refers to, and I quote, each House shall determine the rules of its proceedings. And this has been affirmed several times with the Supreme Court itself. Maraming salamat po sa dalawa po nating ginagalang na maestrado.
Maraming salamat. And Senator Risa, I'd also like to invite at the earliest opportunity, Dean Cheldiokno. Thank you, Senator Risa, please.
Yamanak, Madam Chair. With also thanks to Justices Azcuna and Carpio, just to follow on the one of the statements of Justice Azcuna, Madam Chair. For the record, could we get also the Comelec's position on the proposal contained in the alleged People's Initiative? Amendment po ba yon o revision? Yung proposed phrase po na voting jointly.
Madam Chair, Your Honors, at this point po, talagang umihingi kami ng paumanhin. We cannot render any opinion as regards to this, to that statement as contained in the signature sheet, simply because hanggang ngayon po, yung mga papel po na naandyan sa aming mga local Comelec, these are mere scrap of papers. Wala pa pong visa, wala pa pong kwenta, wala pa pong value until and unless these documents will be used in a formal petition to be filed with the Commission on Elections. So as far as we are concerned, we did not even look into the entire content of the form. Ang tinignan lang po namin doon, numbers and yung number of pages.
Thank you, good Chair, Madam Chair. Although I would have wished maybe the good Chair might have ventured an opinion even as a professor, but if he wishes, then I will just leave it at that. For now, dahil napag-usapan din with Senchis yung usapin ng budget, nabanggit rin po ng ilang Comelec officials na kung magpatuloy ang proseso ng People's Initiative, ay ang gastos dito ay aabot sa 13 billion pesos na magdudulot di umano ng financial crisis sa Commission. Sang-ayon po ba ang good Chair sa statement po na iyon?
Madam Chair, Your Honors, tama po. Simply because we cannot divert anymore any of the funds in the possession of the Comelec or is contained in the GAA, the General Appropriations Act. Kasi po, napakaliit na po na nabigay sa amin preparatory for the national and local election. Take note, Madam Chair, Your Honors, hindi po na-factory in ng lahat yung barangay and SK elections ng 2025. There was the Supreme Court decision which mandated the Commission, directed the Commission to conduct the BSKE by December of 2025. 5 months only after the conduct of the May 2025 national and local elections. Nung mag-prepare po na kami ng budget, Madam Chair, Your Honors, hindi pa po naka-factor in yung BSKE simply because lumabas po yung decision ng Supreme Court only after the budget had been transmitted and transmitted by the executive to the legislative department. And so, napakalaking blessing po sa amin na naibalik yung 12 billion so that we can spend that for the preparation for these two elections for 2025.
Salamat, good chair, Madam Chair. So kahit ayaw pang mag-delve ang Comelec into some of the substantive issues regarding this People's Initiative, at least klaro na rin po sa komite namin na mayroong napakakongkretong mga financial implications kung sakasakali. Isang tanong na lang po, Madam Chair, sa good chair, bago yung unang tanong ko kay Dean Chel Jokno. Mr. Chair, kung ipilit po ipagpatuloy yung People's Initiative at pagdaraos din ng verification at plebisito sa ilalim ng Comelec, paano po ito makakaapekto sa Comelec, lalo na malapit na yung binanggit din ng Chair na 2025 elections?
Maraming salamat po, Madam Chair, Your Honors, and this is an opportunity for the Comelec to clarify. We cannot conduct any plebiscite in 2025. That's a no-no, that's a negative. We cannot conduct the plebiscite even by November of this year to December of this year. Napakaliit na po nung space na ginagalawan po ng Commission on Election. Everybody should be able to understand that when you conduct a plebiscite or even a national or even a local elections, you need such procedural, yung pong processes for procurement. Saan po kami kukuha ng millions ng ballpen ngayon? Hindi po pwede sa PSDBM, hindi po nila kaya yon. Paano po kami procure ng papel para po sa pagpe-print ng balota? You can only do that if the Comelec is able to declare after a very tedious process that indeed the 12% signatures were had as far as those who wanted to amend the constitutions are concerned, and number two, the 3% per legislative district. So napakahaba pa pong proseso niya. Meron pa po kaming determination supposedly under the rules that we have suspended of the sufficiency or insufficiency of the petition. Sabi ko nga po, baka pag-file pa lang po ng petition nila, kulang yung kanila pong petition, we will dismiss immediately if that is not sufficient informed substance. So we have nothing to verify at all. So mahabang proseso pa po yun, and that process, in accordance with our rules, will take several months. And therefore, come to think of it, yung pwede lang po kami mag-conduct ng plebisito sa kasalukuyan, Madam Chair, Your Honors, ay October of this year. But however, October po, filing na po tayo ng certificates of candidacy. And therefore, magkakasabay po yung mga trabahong ginagawa ng Comelec, more particularly, Your Honors, yung registration of voters natin, which we have to start by February 12 up to September 30 of this year. Maraming salamat po.
Maraming salamat din po, good chair, Madam Chair. So again, bagamat hindi pa kinakaya ng Comelec mag-delve into ilang mga substantive issues kaugnay nitong People's Initiative, sa huling sagot ng good chair, Madam Chair, malinaw na may mga limitasyon to what is humanly or institutionally possible sa given yung ibang mga nakaatas na tungkulin sa Comelec even until next year or the year 2025. So maraming salamat po, good chair, Madam Chair. Kung maaari ko pong i-pose yung unang tanong ko, Madam Chair, kay Dean Chel.
Madam Chair, if I may,
Yes, Madam Chair.
I'm sorry, with the indulgence of my distinguished colleague.
Yes, Major.
Just to clarify something on the part of the Commission on Election. If I may, Madam Chair.
Yes, the sufferance
indulgence.
of Senator Risa, our
Madam
majority leader, Senator Villanueva.
Yes, thank you very much, Madam Chair. Thank you, Senator Risa. This is not going to take long. First of all, Madam Chair, let me state for the record my sincerest thanks and appreciation to our justices who came here and gave us a very enlightening statements. Justice Ascuna, Justice Carpio, napakalaking tulong po ninyo sa bayan, lalo po sa mga estudyante ng kasaysayan at estudyante ng pag-aaral ng ating saligang batas, ng ating mga batas. Klaro ho sa akin what is now binding, and ang binding yung main decision, hindi yung dissenting opinion. Klaro din po sa akin yung binanggit nyo kung bakit ang importante na pumunta tayo dun sa basic na premise kung paano in-structure ang ating mga institusyon gaya ng Senado at Kamara de de Representantes, which we all, marami po sa amin dito sa Senado galing, kaya mahal na mahal namin ang HOR. At ito yung dahilan kung bakit importante talaga yung voting separately at magkaroon ng checks and balance. Babalikan ko po yung mga ilang katanungan sa ating Commission on Elections. First of all, we also like to say that it's a welcome development. Ito pong in-issue ng Comelec and Bank para ho isuspend yung all processes relating to the People's Initiative. Chairman George, maraming beses narinig natin ang Comelec at ang mga opisyalis nito na sinasabi na receiving signature sheets is ministerial duty of the Comelec. However, ito nga po yung Comelec nag-announce that it is indefinitely suspending the receipt of signature sheets after 209 out of 253 legislative districts have submitted their signature sheets. We just want to understand this very clearly, no? Sabi nung una, it is ministerial, ngayon pinapahinto. Does this mean that the receipt of signature sheets is not ministerial? Really, on the part of Comelec, and that's the reason why Comelec and Bank came up with this decision, Madam Chair?
Madam Chair, Your Honor, still ministerial, simply because that's part of the guidelines or the rules under 10650. That's the first part po. Although, again, we'd like to reiterate that at that point of the receipt by our local Comelec of these signature pages or forms, the Comelec cannot or had not yet exercised jurisdiction.
Okay, sir, we're not in verifying yet, but in just receiving. So isn't it this decision on how or when the duty shall be performed, which makes it discretionary on the part of the Comelec? Ang point ko lang, Madam Chair, is I wanted to be clarified. Kailan ba ministerial, kailan discretionary? Kasi maraming nagtatanong, and I'm not a lawyer, Your Honor, Madam Chair, parang sa korte ba po pwede ka magbigay ng mga attachment, tapos sasabihin mo, to follow na yung aking kaso, no? Parang ganun ho yung dating sa akin kung magre-receive ka na magre-receive. And while you were receiving these documents and signatures, hindi mo alam kung may mga nagtatanong na, may mga nasa news na nagbibigay ng salapi, mayroong tumutulak na staff ng kongresista, etc. And we can go on and on with all these pieces of evidence that we have collected here. So, ang point ko lang, Madam Chair, is that hindi ba once and for all kailangang mapagdesisyonan? Ito ba ay ministerial or discretionary?
Madam Chair, Your Honor, sabi po ng kagalang-galang Supreme Court at napakadami ng decision. Basta po ministerial, no discretion. We have no choice but to perform such a duty. In fact, yung po ministerial duty can be the subject of a petition for mandamus to compel the performance thereof. Pagka po discretionary, we can refuse to perform such a duty. Ngayon po, para po magkaroon ng clearer understanding ang ating mga kababayan dito po sa pagtanggap ng mga signature forms. Wala po itong pinagkaiba, Madam Chair, Your Honor, sa pagtanggap ng Comelec ng mga certificates of candidacy. Yan po ministerial duty. Kung ang nagpapile po ng kandidatura isang 25 anyos para sa kandidato for president, we have no choice but to accept that certificate of candidacy. But it doesn't mean that the Comelec is now giving due course to that certificate of candidacy. Nangangahulugan, pwede po namin yung i-reject kaagad after matanggap kasi lumalabas, ineligible naman pala yung nagpa-file ng candidacy. But refusing to accept the candidacy, or in this case, the signature forms, baka po makasuhan yung aming mga local Comelec sapagkat, again, ministerial po yung duty in accordance with Comelec Resolution 10650, which we suspended in view of one of these issues po. Yung issue po yan, yung inyo pong nabanggit, Madam Chair, Your Honors.
Thank you, Madam Chair, Chairman George. No, yesterday also Comelec announced that it has received signature forms from 1,072 cities and municipalities as of January 26, 2024. Now, based on Comelec Resolution number 10650, the election officer will issue a certification using Annex B of the resolution. Now, looking at Annex B, nakalagay po dito, may nakuha po tayong dokumento. It specifically says that the proponents submitted signatures of registered voters as petitioners in this petition. So, does this mean that there is already a petition? If there is no petition yet, what petition is the election officer certifying to, Madam Chair?
Yes, Madam Chair, Your Honors. Wala pa pong formal na petition that will trigger the performance of or the exercise of jurisdiction of the Commission on Election. Perhaps what is being referred there, kaya nga po namin sinuspend para maklarify ang lahat, para po mas specific at maayos. Perhaps what is being referred there is the signature form, is the petition by itself. Remember po in the ponencia of Mr. Justice Carpio, it's in the first page ng kanyang ponente po, ang sabi po niya, kaya dinidismiss yung petition doon sa case na yon sapagkat signature forms lang po siya, ni walang nakalagay, basta pirma ng mga tao. So sabi po doon sa ponente, dapat po yung mismong signature form should contain the provision of the Constitution subject of the amendment. So siguro po of the proposal, siguro po yun ang nire-refer ng Annex B na yan ng aming Comelec Resolution 10650.
Sige po, Chairman, no? Just to be clarified again. You look at your decision, paragraph 2 of the said memorandum, it states that signature sheets which have already been submitted before the aforementioned date must be safeguarded and their integrity preserved by the concerned election officers until further orders are issued by the Commission. Now, paragraph 3 of your decision says the proponent can retrieve the signature sheets provided that he or she return the certification. And I suppose this pertains to this Annex B that we just got from our friends. And perhaps if you can also look into this, yung certification, if we have a slide that we can show na ito ay talagang galing po sa Commission on Election kasi Annex B po ito. Are you
Yes, Madam Chair, Your Honors, tama po. Yung Annex B na yan, yun yung certification na ini-issue ng mga election officers ng municipalities and cities once they receive the signature forms. And usually po ay dalawang kopya po yan. Yung isang kopya ay binibigay po doon sa nagdala ng mga signature forms or signature pages sa kanya. At pangalawa po ay yung pinapadala niya sa aming clerk of court. And that's why we can be able to monitor ilan na po yung ipapa-receive sa aming mga signatures and at the same time kung ano mga bayan na katulad po na nabanggit nyo kanina ang nakatanggap na ng mga signature forms based doon sa sinuspend namin na Comelec Resolution 10650.
Madam Chair, if we can also ask Comelec to give us a copy of these certifications. How many certifications have you issued? Kasi ito, certification na to, Annex B na po ito. So, ibig sabihin, I suppose, may Annex A?
Ay, yung Annex A, Madam Chair, Your Honors, yun yung certification from our election records and statistics department of how many registered voters are there in the entire country and how many registered voters are there on a per legislative district of the 253 legislative district nationwide.
And can we see a sample, Madam Chair, of an issued certification signed by an EO?
Yes, Madam Chair, we are willing to submit a sample copy of the certification issued by our election officer.
Yeah. Thank you, Madam Chair. At kung maaari po, makahingi po tayo ang committee na ito nitong certification ito. Maraming salamat, Chairman George.
Madam Chair, and this is a clarification addressed to the good Senator, Majority Floor Leader. What particular province and municipality would a good Senator would like to be given a copy of the certification?
Ito po sana, itong certification na ito na... Of course, siyempre, lahat ng gusto natin, no? But itong certification na Annex B,
Yes,
na
Madam Chair. That's the
binabanggit po
form.
natin.
That's
Oo.
the form, Madam Chair. But the good Majority Floor Leader was talking about a sample of the certification.
I would love to see the province of Bulacan, Your Honor.
On this point, Madam Chair, may we request for all, Chairman Garcia, is this a private document, the certification of the election officer, or is it a public document?
Because it was already sent to our, and we received already that, sent to our clerk of court, then these are already public documents.
Who sent it to the clerk of court, the EO?
The election officers, Madam Chair, certified through copies of the original copies given to the proponent or to whoever have delivered the signature
Well,
forms.
perhaps there is indeed a reason to revise and revisit your rules, because based on my reading of the rules, it says that these certifications will be part of the annex of the petition.
That's
It's
right.
not the petition itself.
That's right, Madam Chair, and that's
So
why...
the petition is separate from the annex, and if that is so, why is the Comelec the one sending the petitions to the main office of Comelec para mas madaling stapler nung, hindi ba obligasyon ng petitioner to gather, when upon submission, to gather the certifications? Of course, merong on file ang Comelec.
Madam Chair, Your Honors, kaya po dalawang kopya, yung original po, yung po yung nasa proponent o kung sino nagbibigay. And then, the election officer will have to send a copy
For validation
for
purposes.
validation later in the event that a formal petition will be filed to Comelec and will be used yung mga binigay namin certification ng mga local Comelec
Yun yung
as
iatas.
Annex B.
As an annex, di ba?
Yes, Madam
Yung
Chair.
signature sheets will not even be an annex yet,
That's right.
right?
Madam.
It will remain in the offices of the EO.
That's right, Madam
Now
Chair.
that you've suspended it, what will happen to them?
Nakalagay po doon sa binasa, Madam Chair, ng ating kagalangaran na Majority Floor Leader, either i-retrieve nila, ibalik nila sa amin yung mga certifications na inisyo namin, or pabayaan po nilang nasa mga opisina namin. We will just take care of
I
all these
understand that,
documents.
but I would like to clarify, Chairman Garcia, may expiration date ba itong mga pinirmahan?
Wala po, Madam Chair,
So,
Your Honor.
pwedeng gamitin next year?
Depende po sa proponent if they will maintain the same provision of the Constitution that they wanted to amend, or they will be proposing a different provision of the
So,
Constitution.
magbabago lang kung may namatay, nag-abroad, o hindi na nakatira doon, o hindi bumoto ng 3 beses, o tatanggalin na sa voters list, yun lang yung magbabago doon.
That's right, Madam
But
Chair.
this exact same document that they have gathered thus far has no expiry date.
That's right, Madam Chair, Your Honors.
Thank you
Madam
for
Chair?
that clarification, Chairman Garcia.
Madam Chair?
Yes, thank you very much. Senator Bongo has been very patiently waiting, and I have failed to acknowledge him. We acknowledge his presence from much earlier on. By the way, we're at the deadline of 2 o'clock, and I'd like to remind Mr. Oñate, we are requesting the donors list. Do you have it now? Hiningi ni Minority Leader yung donors list doon sa TV ad, yung 55 million po. Nasa inyo na yung donors list po.
As I mentioned earlier, I provided the bulk of the funds, and the rest is given by donors, and my lawyers are the ones that will prepare the list.
Madam Chair, if I may.
Yes, Senator Cheese, please.
We are willing to give additional time for you to get the consent too of talk to your donors and get their acquiescence. But as I said earlier, they should have nothing to be ashamed or embarrassed about. May I just assure and ensure,
Next hearing, my lawyers will submit it.
may I just ensure the attendance of Mr. Oñate because like Attorney Abad, you might go abroad again. When are you slated to go abroad again, Mr. Oñate?
Yes.
When will you go abroad again, Mr. Oñate? I understand you're not really based here, so baka...
When will I go abroad?
Yes, because you're not based here, right? So baka delikadong pag
No, I'm
nag-hearing
based
kami
here. I live here. It's just that I travel every now and then.
to...
But I live here. I live here in Manila.
Because you said earlier, yung sa dasma nyo, walang nakatira eh.
That's different because I use that as for entertainment.
But you have a different residence.
Yes.
Mas maganda yung bahay mo kaysa sa entertainment o...
Yes.
No, just wanted to make sure, Madam Chair, that because that you're not based in any way in San Francisco, as I've heard. You're not based in San Francisco. You're based
I have
here.
a slight hearing problem. In fact, I'm wearing a hearing aid. That's why I am not.
It's okay, sir.
Sometimes I cannot hear properly.
It's okay, sir. You're based here in the Philippines and
Yes.
not in San Francisco.
Yes, I'm based here, but it's just that I go abroad every now and then.
Exactly. You're not a resident of San Francisco. You're a resident of the Philippines.
I maintain a residence in San Francisco, but I live here.
You're a green card holder,
I
no?
go there every now and then.
You're a green card holder or ordinary visa lang?
I'm not. I just maintain a residence in San Francisco.
And an entertainment house in Dasma.
Yeah.
Thank you, sir. We expect your attendance in the next hearing, sir. Thank you, sir.
Madam Chair.
Madam Chair?
Senator Risa, please.
Gamanak, Madam Chair. Just to ask my last couple of questions to Attorney Chel Jokno. Bilang human rights lawyer, ano bang mga karapatang pantao yung pwedeng maapektuhan ng Chacha or particularly ng People's Initiative?
Thank you, Madam Chair, Your Honors. Actually, kung sa People's Initiative po yan, it would depend on what the proposal is for an amendment. At klarong-klaro naman na hindi pwede naman i-revise ang ating konstitusyon sa pamamaraan ng People's Initiative. But if I may also address, Madam Chair, the statement made by the Comelec Chair that they have a ministerial duty to accept the signature sheets. My understanding of the law is that the Comelec has a ministerial duty to accept a petition, but not signature sheets alone that are not accompanied by a petition. I believe the Comelec Chair himself said that the signature sheets are a mere scrap of paper, in which case, how can there be a ministerial duty to accept mere scraps of paper? So I think that should also be pointed out. And if I may also, Madam Chair, aside from the lack of a complete enabling law, the fact that the proposed amendment is a revision, that the signature sheets themselves are nothing, and they should never have been even accepted from the beginning by the Comelec, in my opinion. Thank you.
Thank you very
Salamat,
much.
Attorney Chair.
Dean
One last question,
Jokno.
Madam Chair, for
Maybe
Attorney
we
Chel.
give the Comelec an opportunity
Yes,
to
Madam Chair.
respond also to that, because I did hear the Comelec chairman say that without the petition, the signature sheets are mere scraps of paper. So why did you accept these scraps of paper?
Madam Chair, simply because it's provided for in Comelec Resolution 10650, which we suspended in order to resolve issues such as this one, whether or not, for purposes of the People's Initiative, whether or not really the petition should come first or the signature form should come first ahead of the petition. That is one of the issues that should be resolved. Alin po ba talaga ang dapat mauna? Ang petition bago ang signature sheets o ang signature sheets bago ang formal na petition. So, yan po yung isang issues na kinakailangan i-resolve, and that's the reason why isa po yan sa mga bagay na pinag-usapan ng NBank para po mas maging maliwanag kung alin ba talagang una sa at huli sa dalawa.
Madam
Pero
Chair.
dami-dami na ninyong tinanggap eh. I think si Senator Bato has been aching to talk.
Madam Chair, thank you, Madam Chair. Chairman George, habang naghihiring tayo ngayon, marami tayong mga kababayan na nanonood at meron nang nagbabalak na bawiin yung kanilang signature. Will the Comelec allow this? And if you allow this, paano bang gagawin nila? Saan sila pupunta? Pupunta pa ba sila sa Purok, sa barangay, sa Comelec, sa police station, o ano pong gagawin nila para mabigyan natin ng linaw yung paano nila gawin ito?
Madam
Thank you,
Chair,
Madam Chair.
Your Honors, maraming salamat po. Yung po ang kadahilanan kung bakit sinuspend din namin ng rules sapagkat wala pong provision sa Comelec Resolution 10650 ng procedure ng withdrawal ng mga signatures. For example, pupunta ang isang pumirma doon po sa signature sheet, doon sa local Comelec natin. Sure po ako kung naandyan yung rules namin, hindi po papayagan, Madam Chair, Your Honors, ng aming local Comelec sapagkat wala pong nakalagay doon sa amin pong 10650 kung paano magwi-withdraw. At the same time, wala pong form sa withdrawal. So, ibig sabihin po, pagka tinignan nyo ng isang independent person yung mismong aming rules, as if hindi siya pumapayag na may mag-withdraw na kahit na isa doon sa mga signatories.
Mabuti at sinuspend din nyo dahil kung ganun, napakaraming Pilipino ang nababayulit yung kanilang karapatan na bawiin yung kanilang perma. Napakaraming gustong bumawi ng perma ngayon. So, mabuti sinuspend din nyo, Madam Chair, at klaro tayo na yun pala ay hindi na nila pwedeng bawiin. Kahit nasabihin, Kahirap naman, no? Kung mahirap ka lang, no? Pobre ka lang ba? Naisahan ka lang. Now, sige, magpirma kayo dito. Bibigyan kayo ng AX bukas ng 3,000 pesos. Punta kayo, pirma kayo dito. Tapos ngayon, na-realize mo, because of this hearing, na-realize mo na mali pala yung ginawa ko. Yung palang pirma ko ay bininta ko na palang kaluluwa ng Pilipinas doon. Gusto kong bawiin. Tapos hindi pala pwedeng bawiin kung hindi niyo sinuspend yung ginagawa ninyo. So, that will result to something very bad para sa mga tao. Sabihin, porque mahirap lang kami. Hindi na pala namin pwedeng bawiin yung pirma. Nagkamali lang kami doon dahil naguyo kami doon sa inutusan ni Congressman na papirma sa amin. Tapos, ganun, hindi na pala namin pwedeng bawiin. So,
Tama po.
napakahirap po sa isang ordinaryong Pilipino.
Tama po, Madam Chair, Your Honors. Kaya po, nararapat lamang na hindi mo na maipatupad yung rules na yan upang mapagbigyan yung mga ganyan pong... Katulad din po, halimbawa, Madam Chair, Your Honors, yung issue ng pwede bang may observer o watcher during the verification. Wala po sa provision ng aming rules, yung Comelec Resolution 10650. Kunyari lang din po, yung aming pong election officer nag-ruling na ito ay signature ni A at ito ay siya ay registered voter kahit naman hindi niya signature yon. Alam niyo po ba sa rules, final po yon. And therefore, wala rin pong mode ng appeal doon po sa aming Comelec Resolution 10650. So, madami pong mga dapat na ayusin sapagkat we will have to ensure due process and that exercise of the rights of the people who are signing or not signing the signature sheets as well as the petition.
But given that the chairman has watched the videos, has listened to the witnesses, it's very clear that many of those who signed were misled and deceived. You are convinced that, in fact, a procedure for withdrawing signatures when they were extracted so illegally and unethically should be included in the new rules.
Madam Chair, dapat lang po, including po yung issue ng signature buying. Kasi sa issue po ng signature buying, wala po rin nakalagay doon kung paano. For example, meron pong ebidensya laban na si A, ang kanyang pirma ay produkto ng pamimili o pagbibigay sa kanya kung ano man pong binibigay ng pamahalaan. Wala rin pong sinasabi na dapat tanggalin yung pangalan ni A doon sa signature page at payagan na hindi dapat ibilang siya doon sa pagdetermine ng 3% or 12%.
Salamat
Madam
po.
Chair, Madam
At,
Chair.
si
If I
Senator
may lang po,
Bongo,
with the permission
Senator
of
Bongo.
the good chair, since nabanggit po kanina ni Senator Escudero na walang expiry po itong mga signatures na collect, no? Ang tanong ko lang po sa inyo dito, bakit ngayon lang naisipan ninyo ang bank na i-suspend mo na ang proceedings at naging divisive eh. Medyo nagkagulo, hindi nga tayo aabot dito kung earlier pa po na address na po itong problema ito. Bakit po recently lang po na-suspend yung proceedings at bakit hindi nyo muna pinlansya ng mabuti itong mga rules ninyo bago pinatuloy yung pagkolekta? At yung tanong dyan is, inaantayan ng mga kababayan natin yung expiry na to. Until walang klarong sagot mula sa Comelec, ay wala pong tuldok itong naging divisive na issue na ito.
Madam Chair, Your Honors, with your kind indulgence, Commissioner Ray Bulay would like to answer the query of the good Senator Bongo.
Commissioner Bulay, please.
Thank you, Madam Chair. With the indulgence of the good Senator, idol ko po si Senator Bongo, Senator Bato. Simula po kami tumanggap ng papel second week ng January. Ngayon po, January 30. Ang Comelec po, ngayon in the thick of preparations for 2025, and not a single document came to our office. Hanggang ngayon, wala po. And yung aaralin pa namin, yung batas tungkol dito, hindi ho madaling gawin. Kasi po, nagpiprepare kami sa 2025 elections.
na yun po ay babaguhin ang sistema. So dumating po ito, second week ng January this year. Ngayon po, January 30 lang tayo eh. Mabilis pa nga ho yung aming aksyon considering yung workload na dinadaanan po namin ngayong Enero. Kaya humihingi po kami ng paumanhin kung hindi po kami nakakilos agad. Pero sana po maintindihan na hindi lang po yun ang aming ginagawa. And true to the heart, hindi po namin gusto na i-rob ang common Filipino ng kanilang karapatan. We will not stand to that. Ako po ay napapasalamat, Madam Chair, sa oras na ako yung
Meron ho ba kayong formal complaint na natanggap sa mga naiulat na panunuhol in exchange for the signature?
Madam Chair, Your Honors, as of this time po, wala po. At as of this time din po, wala pa rin natatanggap ang aming pong mga local Comelec nationwide. Doon po sa mga 1,800 municipalities and cities na nagwi-withdraw ng kanilang signature. Simply because nga, siguro nga po dahil na-i-announce kahapon, na suspended naman ang lahat ng proseso. So again, in answer to your query, Madam Chair, Your Honors, wala pa po kaming natatanggap na kahit na anong complaint.
Since nabanggit niyo rin po, Mr. Chairman, na noong mga nakaraang araw, di ba may mga pronouncement kayo na bawal po yung panunuhol in exchange for the signature. Since wala kayong natatanggap na complaint, wala ho ba kayong ginawang pag-imbestiga sa mga field offices niyo po?
Madam Chair, kapag po tinignan natin yung mga umiiral na mga patakaran, kahit po ang Omnibus Election Code na under Republic Act 6735 ay suppletory in character. Ibig sabihin, pwedeng gamitin namin. Alam niyo po, sa punto ng signature gathering, wala pa pong jurisdiction ng Comelec. Doon po sa issue ng panunuhol o paggamit ng pondo, wala po kaming jurisdiction. Hindi po siya ma-relate kahit anong stretch ng aming imagination. Yun nga po yung pilit naming sinusubukan na magawa ng paraan. Kasi yung pong issue ng sinasabing vote buying, papasok lang po kasi ang vote buying, Madam Chair, Your Honors, kapag po election period. Yan po yung jurisdiction ng Comelec. And therefore, when it comes to misuse of public funds in relation to signature buying, ang Comelec po ay walang jurisdiction. The most po, magkakaroon kami ng jurisdiction kapag naando na kami sa level ng verification. Pag bine-verify na namin ang signatures, then tsaka po kami mag-entertain na si A, si B, si C, ang buong barangay na ito, kinuhanan ng signatures, binili ang kanilang mga pirma. Pwede po namin ma-entertain. Pero nga po, hanggang ngayon, the Comelec does not have jurisdiction yet. Even at the time of the suspension of all proceedings, wala pa po kaming jurisdiction. Kaya nga po, siguro po, for purposes of legislation, yan po yung dapat maisama kung talagang re-reviewin po natin yung Republic Act 6735. Kasi po, the Comelec cannot punish an act as criminal. The Comelec po does not have that authority to define a crime. Meron po tayong prinsipyo sa batas, nullium crimen nulla pena sine lega. There's no crime if there is no law punishing it. So how can we, the Comelec, punish or even charge somebody violating something or performing an act which to us, under common understanding, is illegal or immoral kung hindi po siya punishable? Siguro po under the Anti-Graft and Corrupt Practices Act, but not under the Omnibus Election Code.
Marami po, marami
Related
akong
follow-up,
listahan
Madam
dito
Chair.
kung ano-anong pwedeng ipataw na parusa na kahit sinasabi ninyo na wala sa batas, napakarami po nito. At,
Madam Chair.
andito yung mga iba't ibang anti-graft, yung revised penal code, ang 2020, may technical malversation po, may corruption of public officials, section 4, andito yung code of ethical conduct natin, yung admin problems, ang dami po rito, tapos yung direct bribery, lahat yan pwede, di ba? So, hindi pwedeng maghugas kamay. Talagang may
Your
mga
Honor,
batas na
we agree, Your
pwedeng
Honor.
gamitin.
We fully agree with the list as mentioned as far as violation of 3019, Republic Act 6713, or even the Administrative Code of the Philippines. Pero, Your Honor, yung pong violation sa Omnibus Election Code, ay unfortunately wala po.
Tama. Nagkakaintindihan po tayo dyan, pero hindi pwede maghugas kamay na walang ipataw na parusa sa mga gumawa nito. Si Senator Risa lang po.
Salamat, Madam Chair. One last follow-up question kay Attorney Chel Jokno, related dun sa line of questioning ng Chair. Bukod sa mga batas na nabanggit na ng Chair, Attorney Chel, bilang criminal lawyer, ano pa bang mga kaso ang pwedeng ihain sa mga taong mapatunayang ginamit, inabuso ang public authority o funds para sa isang huwad na People's Initiative?
Thank you, Madam Chair, Your Honor. Kung if the public funds were used for another purpose other than what they were intended for, iyan po ay papasok sa malversation. Kung sa anti-graft naman, maaari din yan kasi meron na pagbabawal doon to induce another public officer to commit any violation of rules and regulations or the law. So yun po yung dalawa. Nandiyan din po yung RA 6713, Code of Conduct. Even the Ease of Doing Business Act actually has a penal clause that prohibits the giving of government services for a condition that's not in any law. So marami po talagang pwedeng kaso ang isampa.
Salamat, Attorney Chel. Agyaman, Madam Chair.
Thank you very much. And I think we'll have to wind down, but a quick word from Congressman Marcoleta. We have session at 3 o'clock.
Thank you, Madam Chair. I wish to take advantage of the presence of our distinguished former associate justices of the Supreme Court when, in particular, they say that the amended, the recommended amendment to the Constitution by way of a People's Initiative is more of a revision than an amendment, citing that it will violate Section or Article 6 of the Philippine Constitution. Madam Chair, the way this is my personal opinion, when we call for the congressional or the constituent assembly, it's the first mode to amend the Constitution or revise the Constitution. It says, amendment to or revision of this Constitution may be proposed by, 1, the Congress upon 3/4 vote of all its members. So, I'll proceed from that. When the Constitution simply say, of all the members of Congress, it takes the totality of the members of the House of Representatives and then the Senate. Paano po yun, Justice Ascuna or Justice Carpio? Ang sabi po ninyo, if, for example, the members of the Senate would not agree, kunwari po, inimbitahan namin sila, but they did not go there, or probably 2 or 3 only of them came in, and so hindi po represented ang Constituent Assembly. So there will be no time at all that we will be utilize that particular mode of amending the Constitution by simply for the Senate to refuse to go with us and meet with us as a Constituent Assembly. Wala pong mangyayari at yung pong napakahalagang provision na itinakda ng gumawa ng saligang batas para susugin ang saligang batas ay hindi po mangyayari kahit kailan. The House of Representatives will be at the mercy of the Senate. Kasi sasabihin lang po nila, wala po kaming 3/4, sir. I'm sorry. And this has been the case. I have been long enough in Congress to see that our invitations were not even responded to. Wala pong nangyari. The Senate, with all due respect, sat on all the invitations. RBH1, RBH2, whatever RBH. Wala pong mangyayari. Siguro po, sa akin lang palagay, pag sinabi niyang 3/4 of all the members of Congress, we get the totality of the members. Halimbawa po, ngayon po ay 309 ang members ng House of Representatives, there are 24 members of the Senate. We have 333. Three-fourths of that is 249, I think. So sabi po ng ating mga kaibigan sa Senate, madadilute naman kami. Tama naman po yun eh. 300 po kami, 24 sila. But that is the simple language of the Constitution. Yun po yung sinabi. Alam nga naman pong yung 300 ay lulunurin ng isang timbang tubig, Mr. Justice. So kailan po mangyayari talaga? It will not even be in the foreseeable future. Maybe we will wait for all eternity para lang po mapapayag namin ang aming mga kaibigan from the Senate to meet with us. Mag-uusap lamang po kami, hindi po mangyayari. Just the invitation. Wala pong mangyayari. Para pag-usapan namin whether we will vote separately or jointly. But in my own personal opinion, kasi po, hindi po kami gagawa ng batas. When we join ourselves as a constituent assembly, we are not making legislative function. We're not doing legislative function. In the same manner, in Section 18, Article 7, kapag ka po i-revoke natin ang proclamation ng martial law, sabi po ng article, Congress voting jointly by a vote of at least a majority of all its members. Ganon din po yung pagkakasabi. Why? Wala pong legislation involved doon. When we propose an amendment to the Constitution, we are simply a member of the Constituent Assembly. Kaya nga po iraratify po ng ating mamamayan through a plebiscite. In Section 19, last paragraph of Article 7, sinabi, when the President shall have the power to grant amnesty with the consensus of a majority of all the members of Congress. That is not legislative. Kaya po pwede po yung joint eh. Nangyayari lang po yung bicameral pag gagawa po kami ng batas. Tama po yung sinabi ni Majority Leader Joel Villanueva. Magpapalit po kami ng kalye. Legislation po yun eh. So magbabicam po yun. In this case, we are not doing legislative function. We are simply proposing an amendment to the Constitution. That is a constituent power. Ginagamit po namin, that is not legislative. Ang totoo po nun, ang mag-a-approve naman po ng aming proposal, yun pong mga mamamayan natin. Siguro po, Madam Chair, it is a respectful request for everybody to consider na baka naman po hindi separate voting talaga. Kasi po, ang totoo niyan, yung gumawa po ng saligang batas, Madam Chair, kung gusto po niyang i-distinguish, isa na lamang po, sabi po nila, katulad po nung Section 11, last paragraph, Article 7, kung gusto po nung gumawa ng saligang batas na i-distinguish talaga, joint voting, joint assembly, ganito po sinasabi, Section 11, last paragraph, Article 7. Congress determines by 2/3 vote of both houses voting separately, tingnan po ninyo, of both houses voting separately that the President is unable to discharge the powers of his duties. Dinidistingue po niya eh. Section 9, Article 7. In case of a vacancy in the office of the Vice President, the President's nominee from the Senate or House of Representatives shall assume office upon confirmation of a majority vote of all the members, both of both houses, voting separately. So, Madam Chair, may pagkakataon po sa buhay ng ating saligang batas, kung minsan sasabihin niya na, i-distinguish niya, voting jointly, or in joint assembly, voting separately. But in this case po, napansin ko, pagka po hindi tayo gumagawa ng batas, if we are not in a legislative work, ang sinasabi po ng gumawa ng saligang batas, it is simple, the totality of all the members of Congress. Kaya tingin ko po doon, joint voting. Salamat po, Madam Chair.
Maraming salamat, Congressman Marcoleta. Nagmamadali po tayo dahil may session pa kami ng alas 3. Pero huling hirit yata kay sa ating mga justices, kung may maidadagdag po kayo, si Justice Tony Carpio, nagtaas po ng kamay. Perhaps you can enlighten us on what actually was envisioned by both the framers of the Constitution as well as the ponentes of the relevant cases. Justice Carpio, please.
Thank you, Madam Chair. The Constitution expressly provides that Congress shall consist of the House of Representatives and the Senate, period. It does not say that Congress, when performing legislative function, shall consist of the House and Senate. So, Congress is composed of the Senate and the House regardless of what they do, whether performing legislative function or approving the declaration of martial or doing other things. No? But in the declaration of martial law, they have to meet, but the Constitution is voting jointly. It's the only instance in the Constitution that you can find the phrase voting jointly. In other words, this is an exceptional case. That's why if you add voting jointly in another provision, that is an exceptional case that departs from the general rule that the Congress shall be composed of the House and the Senate. Vote, and when one chamber cannot act without the approval of the other. You cannot even pass a law renaming a national road if it is an act of the House alone. You cannot pass an ordinary law without both chambers approving. And the Constitution is the highest law of the land. You cannot just say the Speaker alone shall convene the Constituent Assembly and you need only 255 votes that will all come from the House, and you can disregard the 24 votes of the Senate. That is an exceptional departure. That is a revision. So you cannot do that in a people's initiative. You can do that in a con-con or a con-as. I want to emphasize again, the Constitution is the highest law of the land. If you pass an ordinary law, both chambers must approve. And therefore, when you amend the highest law of the land, subject to ratification, you must also both approve. Thank you.
Thank you very much.
Madam Chair, I made the qualification
I'm
that...
sorry, but I think we're short for time.
Maski na 1 minute lang, Madam Chair, because you know, this is very, very important. Ang sinabi ko
Yes,
po
but
kanina,
first,
kino-qualify ko.
But may I thank Justice Carpio for coming to the Senate
Yes, ma'am.
and enlightening us with his extraordinary perspective and participation in all that
Yes.
past in our history. So, yes, Congressman Marcoleta, we have session.
I made a qualification, Madam Chair, na kapag ang Congress po ay nagsanib para sa Constituent Assembly, hindi po kami gagawa ng batas. Wala po yon. Tingnan po ninyo, Justice Carpio, Section 3, Article 11. The House of Representatives shall have the exclusive power to initiate all the case of impeachment. Hindi bicameral po yun, kami lamang po yun. Yung constitutional, yung commission on appointments, this is an independent body enshrined in the Constitution. Hindi po ang gawain namin po doon ay gumawa ng batas. We are there to evaluate and test the competence and the merits of the appointees of the President. Wala po kaming ginagawang batas doon. That is why doon po voting jointly kami. And we are members of a constituent body. As nasabi po rin CA. Hindi po ba? Pagka po nagkaroon ng trial sa Senate, pagka po yung impeachment, di po kami, ang Senate lang po is dissolved, trial. Nakalagay din po sa Constitution, that is not even bicameral. When a treaty or international agreement shall be valid and effective if concurred in by at least two-thirds of all the members of the Senate, hindi po kami kasali doon. That is not bicameral.
I think I have to terminate the hearing.
Yes, ma'am.
We
Thank
have
you very
only
much.
one room, and this is the session hall. So unfortunately, we'll have to wind this down. I guarantee you there will be other hearings, and you will be duly invited. For the representatives from the other groups, we can invite you at the next hearing. I'm so sorry we have not been able to accommodate all those from DSWD, DOH, DOLE, who were very well prepared to testify. I thank Pirma for coming over. We thank the legal luminaries who have graced us with their presence, and certainly the full force of the Comelec that's represented here
Madam
is
Chair.
very welcome. Yes, Senator
One
Risa
last request, Madam
and
Chair.
Majority Leader.
If the chair may also invite on behalf of the committee, Christian Monsod, also a framer of the 1987 Constitution and a former Comelec chair, to the next hearing, Madam Chair.
Okay.
Yeah,
Madam Chair.
Yes,
Just a
Majority
very
Leader,
quick,
please.
just a very
And,
quick
it appears
reaction.
that, Senator Poe is back. Would you like to add? No. Okay, Majority Leader, please.
Thank you. I just can't help but make a short comment, Madam Chair, because I was listening to a press conference that is now going on with the other house, and some of our counterparts were saying that we should not be doing or conducting this investigation, which I don't feel is proper, Mr. President, Madam Chair. I think it should be noted that a lot of government funds were used, a lot of videos and even recordings, text messages, etc. Yung nakita natin. Sana lahat po tayo on board dito bilang mga kawani ng pamahalaan. Maging interesado tayo kung ginagamit yung pangalan natin, ginagamit yung opisina natin. Sana maging interesado tayo doon sa katotohanan na mayroong mga instances, Madam Chair, na yung naghihirap, naghihikahos na kababayan natin, humihingi ng tulong sa gobyerno, ipagkakait yung tulong kung hindi pipirma. Nakakasalukasok po yun. Kahit sinong Pilipino, hindi dapat baliwalayin yun. And that's the main reason, Madam Chair, that's why we are conducting this hearing. But on another note, because my good friend, our good friend, the brilliant lawyer from the House, Senator Congressman Marcoleta mentioned my name, I think it is clear for our people when we get elected as members of the Senate or the House of Representatives. It's very clear, Madam Chair, that we are not only being tasked to legislate laws. We are tasked even to exercise our mandate, to exercise our oversight function in ensuring the checks and balances exist. May nagche-check, may nagmamatsyag, may nagbabantay sa executive, maging sa budget ng judiciary, dumadaan ho sa Kamara at dito sa Senado. Yung pagpapalit kanina ng kalye, paborito nating example yan, idinadaan sa Kamara, idinadaan sa Senado. Ito pa kayang pagpapalit ng kaluluwa ng bayan? Isang boto lang? Ibig sabihin, yung bumoto doon sa Batanes na 7,000 votes lang, congressman ka na, versus ang pinakamababang senador na na-elect, 15 million votes. Pareho lang yung boto nila. Ganun ba talaga yon yung intensyon ng framers of our Constitution? So I just wanted to put that on record, Madam Chair, and again, appeal to our colleagues, to our counterpart, na hindi po biro itong nangyaring peking initiative na ito. Marami pong nagrereklamo. Tao ho, humihinga, naghihingi ng tulong sa gobyerno, nagdarahop, dinadanglel yung AX, pag hindi ka pumirma, hindi kita bibigyan. We should all be united on this matter, Madam Chair, na i-reject natin ito, siguruhing panagutin kung sino man ang nasa likod nito. Maraming salamat, Madam Chair.
Maraming salamat, Madjo. At ngayon, para panghuli at At narito ang ating kaibigan, Senator Grace po, nakasamahan ko sa pag-aamyenda ng economic limitations na nasa ating saligang batas through the provision of law. Senator po.
Thank you, Madam Chair. Gusto ko lang malaman din ng ating mga kababayan sapagkat ang kanilang itinutulak ay economic provisions di umano sa pagbalangkas ng pagbabago sa saligang batas. Katulong din ng House of Representatives, ang Senado ay nanguna upang ipasa ang tatlong napakahalagang mga batas na nag-aamyenda ng mga provision para sa ekonomiya. Unang-una na po ang Public Service Act na napakatagal na po, lagpas 80 years old na yata yung batas na yan. Pangalawa, ang Trade Liberalization Act na pinangunahan ng ating minority leader. At pangatlo, ang Foreign Investments Act na pinangunahan naman ni Senator Amy. Lahat po yan ay nakatutok sa pag-amyenda ng economic provisions. Hindi naman pag-amyenda, kundi pag-clarify ng economic provisions sa ating batas. Katulad sa Public Service Act, ngayon liberalized na po ang mga bagay katulad ng telco, kaya pumasok yung SpaceX ni Elon Musk. Para dun sa mga malalayong lugar, meron tayong service. Niliberalize din dyan ang transportation except dun sa public utility vehicles sa mga jeep. At kasama na rin dyan pati na rin yung mga trains. So kung may mag-i-invest para dito sa atin. So hindi po totoo na pagdating dito sa economic ay may problema tayo na kailangan, meron kulang, maaari, pero ito po, yung mga major ones ay nagawa na natin. Kung meron mang dapat ayusin, ay ang pagtutol ng ilan sa Supreme Court dito sa Public Service Act. Siguro pwedeng magsama ang Kongreso, Senado, at mga mamamayan na doon natin resolbahan sa Supreme Court itong ibang kakulangan sa provision ng ekonomiya. Maraming salamat po.
Maraming salamat at nagpapasalamat ako muli sa partisipasyon ng lahat ng dumalo at asahan po ninyo, marami pa tayong tatawagin, yung Attorney Tony Abad, abangan natin pagdating sa Pilipinas, ang Change Philippines at yung mga binanggit ng mga testigo mula sa Bukidnon at inaabangan pa rin natin kay Mr. Noel Oñate yung donors list at kalakip nun, yung iba't iba pang hiningi ng ating kasamahan mula sa Comelec na mga papeles at dokumento na nagkaklaripika ng proseso ngayon sa mga pirma na naibigay na at ang gagawin sa mga petisyon na hinaharap. Maraming salamat po sa inyong lahat, higit sa lahat sa dalawang justice po natin, Justice Carpio and Justice Ascuna. Thank you, and with that, this committee hearing is hereby suspended.